During this Halloween, you can expect little kids to come up to your front porch and trick or treat. They will expect candy from you. But do you expect a police officer to come up to your porch and have a canine with him to sniff for drugs? Even a better question, is that constitutional under the Fourth Amendment? This is a Supreme Court case, Florida versus Jardines, and the facts are pretty simple. We have police receiving a tip that marijuana is being grown at a certain residence.
It's a night of screams.
We come for you, Martin.
Oh, man, can we all just get along?
Two police officers and a canine go out to the scene. They observe the home from distance. They don't see any foot traffic going in and out of the house, and they don't see any vehicles parked in front of it. So after 15 minutes, they decide to approach the front door. One of the officers has a canine on a 6-foot-long leash. He allows the dog to be in front of the home, and eventually the canine sits down at the base of the front door. Now that's a signal to the handler that there's narcotics inside the house. With that information in hand, the police officers go to a magistrate and they receive a search warrant to search the home. They find narcotics there. And of course, Mr. Jardines is then prosecuted for growing marijuana in his home. Mr. Jardines, however, argues that the initial observation by the canine is a search in itself under the Fourth Amendment. And because it's an illegal search, meaning that the officers did not have a warrant to have the canine in front of the front door, all the evidence that's found inside the home should be suppressed as fruits of an illegal search, under the fruits of the poisonous tree doctrine. So let's review the case law. The Fourth Amendment provides the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. So there's no question that the Fourth Amendment applies in this case. After all, the word house is explicitly written in our Constitution. And of course, we can move on and discuss cats and the reasonable expectation of privacy. I have a video which I will link it here above, and I encourage you to watch it. It discusses cats and the reasonable expectation of privacy test. But here, the question is more fundamental. And really, cats never added or subtracted from the baseline on how we look at the Fourth Amendment. We can always evaluate a search based on trespass laws and whether there was a physical intrusion. A person can always retreat and be secure in their own home. And if an uninvited guest enters your house, of course you can later sue them for trespass. And if that somebody is the police, then the Fourth Amendment protects you. Now, the Supreme Court has extended the boundaries of your home. The areas surrounding your house are also protected. We call that area curtilage. And there is no question that the two detectives had 4 of their feet and their companions 4 firmly planted on Mr. Jardines' property, deeming this a search under the Fourth Amendment, and illegal search because the officers did not have a warrant prior to approaching the front door. Now, you might be asking a valid question that the government brings up. Wouldn't a normal citizen be allowed to approach the front door and ring the bell? And the answer is yes. We look at customs. People are allowed to approach the front door, ring the bell, wait a couple minutes, and if nobody answers, leave. We don't expect our guests to then walk around the home and peek into our back window. That wouldn't be allowed. We also don't expect our guests to arrive with a metal detector and run it in our front yard. We also don't expect police to come to the front doors and sniff for drugs. If you enjoyed this video, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know.